Mutual Property Management LLC versus Portia Griffin and all other occupants of City of Detroit. This matter is scheduled for bench trial today. May I have appearances, please, beginning with the plaintiff?
Miss Portia Griffin, who's to my left.
Ms. Griffin?
Portia Griffin.
Okay, Ms. Griffin, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. You can lower your hands. Okay, so this matter is scheduled for a bench trial, as I indicated before. I have in front of me a dismissal order. I also have in front of me an objection filed by the defendant. Defendant's objections to plaintiff's proposed dismissal. Can you please tell me very quickly, counsel, why you're objecting? Well, let me note that this is not signed by Attorney Ogletree. So are you in agreement with the objections that were filed by Ms. Griffin?
Yeah, I'm advocating on her behalf. So Ms. Griffin is indicating in regards to today's schedule for trial today is for indicated. She indicates that the dismissal paperwork that was filed by the attorney is incorrect, that she did file an answer. Says she's been doing in good faith. We filed exhibit list, witness list, exhibits. The plaintiff hasn't done any of those. Court order proof of ownership be filed. Instead, Ms. Griffin was served with a 30-day notice to quit. Further, in regards to this, that there was, in terms of documentation, she's received no documentation in regards to this case since roughly the same documents that was presented in January of this year. But today, again, still stands no proof of ownership. My client says she's been dealing with faith. She asked that she be allowed to continue the trial, but it's still a violation of due process. I guess we would ask for a judgment, $0, with Ms. Griffin remain in possession.
All right, Attorney Bajani, you filed this motion. Not a motion. Well, I guess it is like a motion. You submitted a dismissal. What is the basis for the dismissal?
Judge, I don't think we really need one, but I can give you a basis for it.
What is it?
The basis here is that my clients no longer wish to rent this property, especially to the defendant, and therefore we'd rather just seek possession of the property. So we hope to dismiss it and then we're going to refile the termination.
Attorney Ogletree, I mean, if the plaintiff, it's the plaintiff's burden to move forward with the case. And if the plaintiff doesn't want to proceed, you know, I can't make him move forward with the trial.
What we're asking for is just a judgment of $0 because today's set for trial. It should be a $0 judgment. My client is filed by the court.
Judge, we would object to that because that would mean that we fully adjudicated this case, which we're not.
Well, it's out.
And there's no counterclaim. Had there been one, then in this case would be different. But like you said, if I have the burden of proof, if I just sit here and not talk or just sit down and not file anything, the court eventually will dismiss the case.
That's true. I mean, he hasn't. So you stated that he didn't submit the deed. Usually, when somebody doesn't submit the deed, I dismiss the matter because that means that they have not sustained their burden. So if they're going to move forward with the complaint to recover possession of property, if it comes back before me, I don't know that it will. He's still going to have to submit the deed and prove that he owns the property before this court grants whatever relief he's seeking. But I mean, he hasn't done, according to what you just said, Attorney Ogletree, he has not sustained his burden if he has not submitted a deed. And that is a grounds for dismissal in most, you know, in my courtroom sometimes. I don't know if a lease agreement has been filed. This is a relatively thick document. And so I mean, a relatively thick file. So just as I'm speaking to you all right now, I don't know if a lease agreement has been filed, but I mean, the plaintiff, this is plaintiff's burden and he doesn't wish to move forward.
My client just wishes that this case has went on since October. She's requesting final determination this case? I mean, this.
No, he's dismissing the matter. If I enter a judgment against you, even if it's a $0 judgment, it's still going to be against you. You want a judgment in your name, ma'am? No, you don't. I can tell you, no, you don't want a judgment in your name. And that's, I'm not trying to give legal advice, but no, you don't want a judgment in your name, even if it's for $1, even if it's for $0. You don't want a judgment in your name. So I don't understand what is fueling the desire to move forward.
I mean, I guess he's been served with another notice. Not before the court yet, but while this case has been pending, a 30-day notice. So it looks like it's gonna turn right back around, roughly this month and be a whole nother case and possibly go through it in a whole nother 3 months.
Well, yes, but that's giving you more time to stay in the location, ma'am. I understand. I don't know. Let me see. So from my notes from previously, I think plaintiff asserted there was 11,000, roughly about 12,000 due, and then defendant asserted maybe like 4,500 or something like that. So there's a dispute as to how much rent is due and owing, right? Okay. So if there's no lease agreement in place, even if I did adjudicate this matter and say, okay, well, you pay $4,600 or vacate within 30 days, once you pay that amount, if there's no lease in place, then the next month the plaintiff could still file a complaint to recover possession of property. So
I understand Ms. Griffin said she was to address the court possible.
yes, Ms. Griffin.
Yes, I was giving a lease agreement with mutual property because they were out of compliance, and they reached out to me, so I helped them get back into compliance, and I do have a lease agreement from mutual. However, and right now however, I did an e-signature. And after I did the e-signature, they presented me with the new lease.
Well, did you get it when you do an e-sign? Don't you get like verification that comes to your email?
Yes, it came through my email.
Okay, so then you have a copy of the lease, right?
Yes, but 975. However, Your Honor, they're asking me to re-sign the lease because they had some incorrections on the lease, like my birthday. Okay, well, I don't know what's going on with that. All I'm telling you is it makes absolutely no sense for the court to enter a judgment against you, even if it's for $1, because then there's a judgment in your name, and that is not favorable when you try to apply for credit or something like that. It doesn't make sense for the court to issue a judgment, and so I'm not going to do it, especially since the plaintiff is dismissing it. Well, Your Honor, the first summons that was brought against me from the plaintiff, I've answered, and I've gathered all my documentations, and just to turn around and for him not to submit anything to the court, and
that would be another grounds for me to dismiss the case. So it sounds like he's not prepared. Well, I don't want to say you're not prepared, Attorney Bajani, but what I'm saying is, if you're supposed to submit something and you don't submit it, I'm dismissing your case. And so I mean, everything that you're saying, arguing for me to continue with the trial, is actually a reason for me to dismiss the case, because it's Attorney Bajani's client, it's Attorney Bajani's client's burden, and they're not prepared to proceed today. And so, I'm dismissing the matter. I'm not going to have a trial. I don't see a file or anything on his desk. He doesn't look like he's ready to go to trial. He's dismissing the case. So it's dismissed. I mean, I don't know. Maybe you can talk to your attorney, and I'm sure you will, Attorney Ogletree, talk to her more. But to me, it just makes no sense to proceed with a trial that will ultimately Because you're not saying that it's zero money owed. You were saying that there was like $4,500 owed. That's what you said last time.
So, yeah, that was, I was basing that, I didn't have anything to base it against except for the last agreement that I had, which was 604. What?
No, the court has made its decision.
Yes, I made my decision. I'm dismissing the matter. I mean, I'm noting your objections, but it's the plaintiff's burden to proceed and he doesn't wish to proceed. So that concludes this matter. I'm signing the dismissal order now. Thank you all for your patience.
Thank you, Judge. Well, the same to you, staff.
Thank you.
Can I just